Hi, my name is Jatin Popat. I'm a lawyer by profession and past 30 years I am into legal services. I'm a founder of a company called WillJini, which is India's first succession services company, and we have been providing will writing and succession matters to thousands of Indians residing in India and abroad NRIs since 2014. Today we wanted to explain little bit details about situation where person is not write a will and he is died. जब आदमी विल बनाए बगैर यहाँ से दुनिया को छोड़ देता है, तब फैमिली में क्या होता है, कैसे उसका संपत्ति का डिस्ट्रीब्यूशन होना चाहिए या क्या प्रॉब्लम होते हैं. सो आपको मैं बताना चाहता हूँ, जब किसी ने विल नहीं लिखा है तो ये सिचुएशन हमारे एक ज़माने में बहुत पुराने टाइम में देख रहे थे कि एक ट्रेडिशन था, हमारे एक कल्चर था कि फैमिली में जो भी है वो हमारे पेरेंट या जो लीडर है वो डिसीजन लेता था. फैमिली के हर मेंबर को उसमें अपना क्लेम लेना या मांगना कोई सिस्टम नहीं था. सो बेसिकली द पीपल when they don't there was no practice of writing a will in past because there is a tradition. There was a tradition all along. Today the things have changed. Money has become more powerful than the relations. That is what I think we all agree. The succession laws in India is made in 1925. So we know that all those olden days, people don't used to practice this succession law very strictly. People don't used to demand or claim. But things are changed. Things have changed because of the wealth size, because of the relationship and all. So today, writing a will is more important. But many a time, a person has not written a will. Now the person has not written a will and he dies, then what to be done for the wealth? How to be distributed to the family members and in what ratio? Now those questions is answered in the law. Like there is laws in India is based on personal law. So for Hindu, there is a Hindu Succession Act. Then there is a Parsis Christian, they have to follow the Indian Succession Act. For the Muslims, there is a Sharia Law. So these are the things that one has to follow to understand how this wealth to be distributed. For example, a male Hindu person dies at the age of 65. Then his whatever investment or wealth, immovable, movable, whatever, whom to be given and in what ratio. So for the male person who died without a will, his asset will be given to the mother, if mother is living, wife, and all the children, their sons and daughters. Even daughters are married then also. So what happens? All the persons are getting equal shares. So for example, mother is living, there is a wife, there are 4 kids. So totally there will be 6 people, they will be getting equal rights in the wealth, 15% or something like that, right? So but the person was when having a wish that no, everything my wealth should be given first to my spouse and then to the children later on. So those wishes, if he has not written down on the will, there is no point. Because if there is no will, then the law will come in the place to decide. And those laws are very clear. So if people have decided not to write a will and let the law decide, it is okay. Then the law will take care on time. Now, after having this list of the people who are family members, whether it's a Hindu, Christian, Parsi, Muslim, if there is no such succession planning or any document, they will approach to the court of law to decide whether who are the legal heirs and what is the percentage to be given. So those process of claiming the asset will be very difficult. It will be full of hassles. It may take a lot of time and effort and money. There is a requirement of either of a letter of administration or a succession certificate. It could have been resolved very smoothly if person has made a will, he might have registered it. Then the wishes are clearly mentioned in the will that how to be distributed. So to avoid those misunderstanding or to get exactly what is to be done for the wealth, those things are very clearly mentioned in the will. But there is no will, so everybody is confused. Each family member will start thinking in their own understanding. There may be a lawyer coming in the picture in the family. Each family member will bring the lawyer and there could be a fight. We have seen this in various big cases in the media for the large family of the big assets. They fight openly for the businesses and the wealth. It is not only the big families, even the smallest family member, when they don't know who is taking what, they obviously will have misunderstanding and fight, and there is a court cases. So all these things can be curtailed if by writing a will. Non-writing a will is clearly a big problem that you are keeping behind for your family to resolve by way of understanding what are the wealth you have, whom to be given, in what ratio, and there is a legal process. So all this bundling, if you do, it is a big mistake that wealth you created, but you have not written a will, and you have given a pot of the troubles to your family instead of a wealth. So it is good to write a will and avoid those type of procrastination that I will do it later. Nobody knows date of expiry. So earliest is the best. You can make as many will as you want, but writing a will can resolve lot many problems for your family and their happiness and bonding. Thank you so much.